to travel both outside of the country and inside and then return to the country. And I think the blanket ban that has been placed that individuals then need to apply for an exemption for has serious questions under the Biosecurity Act under which it's legislated for, because that act itself says that any decisions under that act must be appropriate and adapted to the end that they're seeking to achieve, and the least restrictive way of doing so. And I don't think this is the least restrictive way of managing that the health needs.
So who would be targeted here, the federal government or the state governments? Because it's the state governments, as we've just seen in WA, wanting to restrict the number of overseas travellers coming home.
So yes, this is a really interesting aspect of our constitutional framework, that the Commonwealth have legislated the Biosecurity Act itself. It's a federal act which restricts people leaving the country. But the states are, of course, politically involved in and have been involved with the decision making through the National Cabinet in relation to this regulation. But ultimately, it is the federal government that has the responsibility for quarantine and for movement of people in and out of the country. And ultimately, the leadership from the federal government is constitutionally there for it to actually better essentially balance the needs of Australian citizens who are both here in Australia and those who are outside of Australia, who are part of the responsibility of the federal government.
Absolutely, and if we're living with this disease for quite some time, years to come, yes, it is a real live issue, and we saw threats of big fines and even jail if Australians use that loophole in New Zealand. Now, do you think that can actually be brought about, or is it just a threat?
Look, it's really interesting. The court would ultimately have to make this decision, Laura, but in essence, anyone who was found responsible for and had such a fine placed against them, I think would have a legal argument in response to say that that fine is actually an unlawful fine and could be resisted on that point. But it would be a matter that would have to go to the courts. But there are very clear legal precedents in relation to a government only being able to legislate and to impose fines within the legislative power under which it's acting, and this legislative power has pressures upon it.
What do you make of the UN ruling that said it was unlawful for two men, Australian men in particular, they were stopped from coming home because of various barriers, some were financial, some were logistical. The government, I think, is yet to respond to that, but does that ruling have really any power?
So that ruling actually resonates in terms of the language that's used in the Biosecurity Act. So Section 12 of the International Covenant on Civil and Political Rights, which Australia is a signatory to and has acceded to and enabled those individuals to go to that committee to complain of its breach, is quite clear about a person's right to both travel out and return to their own country. And so the fact that the Human Rights Committee put an interim order in place requesting Australia to facilitate the return of those Australians is a reminder that the Biosecurity Act that mirrors that legislation is limited by those principles too. So I think that even though there's no police force of the UN to actually force the Australian government to act, Australia has said that it will engage with that finding, and it will be interesting to see how it navigates that in relation to its commitments internationally, as well as internally to the responsibility to Australian citizens.
Well, Kim Rubenstein, thank you so much for reminding